If you go to a restaurant and have a glass of wine, you can be arrested for DUI if you're stopped by a police officer. If you go to a friend's house for a dinner party and have a glass of wine or a beer, you can be subject to a DUI arrest. The worst part about getting a DUI is you go to jail for 8 hours when you get arrested. You should never have to go back to jail. And the second worst part about getting a DUI is the possibility of losing your license. We will strive both to keep you out of jail and to minimize any license suspension as a result of a DUI arrest. A first offender should, if guilty, if has no other choice but to plead guilty, should not be going to jail. A first offender should not be getting anything more than the minimum mandatory sentence allowed by law. A first offender should be able to have every benefit of the doubt and to make this as convenient as possible. In our country, we have certain rights, and the rights are that the government has to prove us guilty beyond a reasonable doubt, and also that the government cannot take anything away from us, whether it's our driver's license, our property, or our privileges, until they give us notice that they are able to take it away, and then an opportunity to challenge them as to why we think they should not be allowed to take away our license. With a DUI, we have 10 days to effectuate that challenge. You need to hire a lawyer right away. As soon as you get out of jail, get showered, get cleaned up, you need to start looking for a lawyer. The reason is because there's a clock that's ticking. Number one, when you get arrested for DUI, you lose your license. When you get home from the jail, you do not have your driver's license with you. That is because the state is trying to take your license away from you, in addition to prosecuting you for the crime of DUI. So one of the first things you have to do is research, find an experienced local attorney who can preserve your driving privileges and keep you driving for as long as possible. So, by getting to a lawyer in time, by getting your challenge in on time, we will be able to keep you driving for at least 30 to 45 days with some restrictions, but you'll be allowed to go to work, to go to school, to go to the doctor, take your children to school, to maintain your livelihood while this case is pending. It's important that you effectuate this challenge because it gives your attorney an opportunity to challenge the case before a prosecutor ever sees it, before a judge ever hears it, and ultimately, obviously, before a jury ever hears it. We get to interview the witnesses live under oath without the presence of a prosecutor or a judge to listen to it and be able to formulate your case while at the same time preserving your driving privileges. While that's going on, the state attorney's office is going to be reviewing your charges to see if there are sufficient facts in order for them to feel that they can prove your guilt beyond a reasonable doubt. So the reason we challenge the driver's license suspension is to, number one, keep you driving as long as possible, and number two, to use it as a discovery tool or an investigative tool to look for things that we can use in your criminal defense to get your charges either dismissed, reduced, or minimized as much as possible. We will handle all of that for you here in this office. As former DUI prosecutors here in South Florida, we're very experienced with how the process works and what needs to be done, who needs to be spoken to, when they need to be spoken to, and what information needs to be brought to them. That doesn't mean that we're able to get every case dismissed because not every case has the right information. But we are properly trained and experienced to look for that information and dig it out and present it whenever it is and wherever it is possible so we can get the best result for you in your case.